I came into the enforcement division and, restructured the entire division, made it smarter and more forceful and more aggressive, brought a record number of cases arising out of the financial crisis. I think 60 or 70 CEOs, CFOs, and high-ranking corporate officers, created a dedicated unit whose job it was to do nothing but go after these cases, brought a record number of cases. Mary Jo has come in with her own enforcement director, and started to require admissions in more numbers of cases, and has prosecuted a number of financial institutions. So I don't know what evidence there exists to suggest that anything other than vigorous enforcement is going on. There's also been academic studies that you may have seen. Has actually gone back and looked at former SEC officials who then went to work for defense firms, and whether or not the outcomes for clients that they represented before the SEC differed from those who didn't used to work at the SEC. And the findings of those studies show that, in fact, not only is there not any difference, but in some respects, the clients of former SEC officials faced tougher resolutions than those who didn't. And the last point I would make is that one of the great benefits of having individuals come from the private sector into the public sector and back again is twofold. One, you want to attract the best talent you can, and people with sort of up-to-date, current knowledge about the practices of the financial services industry. And you get that by attracting people from the private sector to come in and work. If you want that, if that's desirable, then you can't restrict their ability at the back end to go out and make a living. You can't bar them from going back to work in the industries that they were from. What you can do is impose very strict ethical and recusal restrictions on them when they leave, which is what the SEC has. I can't appear before the SEC for a year after I left under any circumstances. I can never appear with respect to, or be involved in any matter that I had personal and substantial involvement with. I cannot appear in any matter that was in the supervisory chain that was under investigation while I was there. I can't receive any compensation for my law firm that's derived from matters that I might otherwise be recused from. This is all under threat of criminal sanction. That's not to mention, bar association and ethical restrictions that are imposed on the legal profession. So there's a great number of restrictions. And the last point that people, I think, don't appreciate it is that when people work at the SEC or the Justice Department and then go work in private industry, those people are ambassadors for compliance and lawfulness. That they can walk into the CEO's office and say, I used to work at the SEC, I used to work at the Justice Department. I'm telling you, if we do this, this is what may well happen. And that person has credibility and stature in a way that others may not. And so they carry a greater deal to bring about that good corporate behavior. So it's not that I don't understand the criticism, and I agree completely that you have to be very vigilant to make sure that doesn't happen. But the benefits to having people come in and out of government are so significant, with the right ethical restrictions on the way out, that I think on balance the system works extremely well. The last point I guess I would make is also, if you think about it, at the SEC, if you're an SEC lawyer and you want to not only do your job well, but you want to establish a reputation, a good reputation for being a good SEC lawyer, and maybe even you're doing that in part because when you leave the SEC one day you'd like to get a good job, the way you do that is by being aggressive and vigorous and hardworking and bringing big and significant cases. Those are the people who excel at the SEC. And if you're an employer on the outside, that's the person you want to hire. You want to hire the person with the sterling reputation as an SEC lawyer, who'd be smart, good judgment, aggressive, fair, well respected by their colleagues. The person who meets that standard is not the one who somehow is trying to curry favor with some future employer by by not being as vigorous as he should. The other point I would make about the SEC is that the SEC enforcement process has so many people involved in it that I don't think it's even possible for someone by themselves, if they were trying to soft pedal a certain case, could really achieve it. I mean, in the SEC investigative process, there are multiple people involved in the investigation, supervised by multiple people. The entire recommendation and all the evidence gets reviewed multiple times up the chain. Then it gets distributed to all the other divisions, who are not the enforcement divisions, but are the rulemaking divisions, the substantive experts to review. Then the Office of General Counsel reviews it for the legal theories. Then all the commissioners and their counsel review the recommendation to see their views. That process, while often time-consuming and sometimes even unwieldy, does reveal, does establish in the end a very thorough and fair process where no part of that case is not scrutinized. And so I think that even the most cynical commentators would find it difficult to conclude that that an individual could somehow put their thumb on the scale there to achieve a certain result that wasn't appropriate.